The Supreme Court has issued notice and agreed to hear petitions to stay the operation of various anti conversion laws that have been passed in at least 10 states in the country. We're speaking to Senior Advocate Vrinda Grover, who is appearing for one of the petitioners in this matter. Ma'am, first of all, welcome. Thank you for joining India Today on this issue. We're talking about what has been happening with these anti-conversion law. First of all, for our viewers, could you just tell us what happened in the court today and when are we likely to hear this matter?
Well, it's a batch of petitions which have been filed by a range of petitioners challenging the different laws passed by states which go under the name of freedom of religion, but that is actually more of a misnomer. What these laws actually do is to create so many hurdles in the exercise of freedom of conscience, as well as people who may choose to voluntarily, freely convert or make marriages of their choice. So while it is a facially neutral legislation, we do know both from the experience now over the last 4 or 5 years, as well as otherwise, that it has a very targeted impact both on religious minorities as well as on women, particularly young men and women who wish to freely exercise their choice, particularly choice of intimate partner, choice in marriage. For instance, I represent the National Federation of Indian Women, which is a national organization. And the reason that we have gone to the Supreme Court is to draw the attention of the court to how this actually strengthens the stranglehold of patriarchy, as well as other forms of socially regressive social streams, which do not want young people to make choices transgressing caste, religion, etc. But we do know that it does have a very direct impact both on religious minorities exercising their faith, as well as young women making choices of intimate partner and marriage.
Ma'am, if we can go through what happened in the hearing today, you had placed certain averments
Right.
before the court. Senior Advocate CU Singh also raised
Yes.
certain arguments,
So we have
particularly
all
with
been,
regard
yes,
sorry, if I may just,
yes,
particularly with regard to the harsh bail conditions and the
yes,
harsh punishments. Could you take us through what that
yes.
is?
So we've all been, these petitions were initially, if you recall, they were filed in different states. For instance, I had filed against the UP law and it was pending before the Allahabad High Court. At some point, the Supreme Court asked for all the petitions to be transferred to the Supreme Court. They have been now pending in the Supreme Court almost since 2022. And one of the things that we have been repeatedly urging the court to take up is that in the operation of this law, people are getting arrested, people are getting incarcerated, people are facing criminal trials. There is legal harassment. And there are many elements in society who are actually abusing this process of the law. What we have been asking the court repeatedly is that please hear us on the issue of stay of certain provisions of these laws. There are about 8 to 10 such state legislations now. Recently we have seen, for instance, in UP, Haryana, there have been amendments to the law. What are those amendments about? They are making the penalty very, very harsh. In fact, it is being equated with, sentences which are awarded usually for attempt to murder. It is saying there will be 20 years minimum or for the remainder of natural life. Now, these are sentences that under Indian penal laws are awarded for very, very heinous, grave offense. These are being equated with those, as well as the bail conditions are so difficult and stringent that people are incarcerated for long. And now we are seeing that there are acquittals that are taking place. So that was what was being urged today before the court, that please list this for urgent hearing for directions.
Now, when you're talking about this request for urgent hearing, as you pointed out, these matters have been pending. Some of these have been pending since 21, some since 22. And the suo motu matter, where the court transferred all matters from high courts, has been pending since 2022. So why an urgency now?
Well, the urgency has been for long. This is not the first time we mentioned it. I recall very clearly mentioning it before the previous Chief Justice of India also. And we were told, well, it will come up soon after the new Chief Justice takes over. I mean, I recognize that the Supreme Court is burdened, but I think when it comes to issues of personal liberty, particularly in laws which have draconian provisions at one end, and at the other end, it's so open. The very crafting of the law is such that it lends itself very easily to misuse, abuse by all and sundry. Anyone can file a complaint against anyone. And we are seeing this play itself out. So there is an urgency. It has been reiterated earlier, and I really do hope that this time there is a hearing within 6 weeks, so that at least the pernicious aspects of this, which is targeting people and not only depriving them of their liberties and fundamental rights, but actually putting them behind bars, it's also having a chilling effect in society and is a cause of social tension today. So for a host of reasons, it needs to be addressed, at least on the aspect of immediate stay of certain provisions.
Ma'am, when you're talking about the fact that this matter has been pending for a while, I do recall there was notice issued to almost all of these states in 2022. Have any of the states responded? What is their response? And secondly, the second part of this is I do recall a hearing, I think in April or May this year, where the Solicitor General had denied these allegations of misuse, said that there's no evidence of misuse. What's your response to this?
So all the states have not yet filed their responses. Many of them have not served us, so it would be premature for me to say. But I can say with some responsibility that what is the position they're taking, including what the state has been saying in court before the Supreme Court. The way it is being presented or projected is that there is some kind of, and we see this as a narrative that is being built. It is unfortunate when certain kinds of narratives are then drawn into, they feed into legislation and enter the courtroom, that there is some large scale conversion taking place, of which there is zero.
I do recall an argument being made that forced conversions are a threat to national integrity. That is an
Yes,
argument that was made by the Solicitor General.
yes. There is, what is a forced conversion? That is a matter of evidence. What is allurement? What is a better way of life? The language is so loose, vague, and overbroad. One fundamental cardinal principle of a criminal legislation is it must be the provisions which codify the offense. The language must be pointed, specific, so that there can be no scope of any misuse. These are an illustration of how a criminal code should not be crafted. Secondly, when we are constant, we have evidence. What is the evidence? The evidence is orders of the high courts as well as the Supreme Court, and acquittals by trial courts. What is called by the terrible phrase called love jihad, which in itself is a political creation. There are acquittals taking place where the court is saying, judicial orders after evidence are saying there is no evidence of this. So when we say that there is material, we are actually showing evidence from the judicial record itself. And we also know that many young people are not being allowed to exercise their fundamental right. And I also want to address the question of national integrity.
Just one small sorry. Please carry on, because I have one small question. Because
Sure.
one thing that all of these laws seem to have in common is that conversion for marriage has been
Yes.
made illegal.
Right.
Isn't that part of the law earlier also, that conversion solely for marriage is not valid?
See, what happens is that how do we determine? How will you determine that somebody is converting for marriage or not converting for marriage? And see, what is always prohibited is any form of force or fraud through which any person is asked to convert their religion. That is prohibited and ought to be prohibited. What happens here is that if I wish to convert, if I wish to marry, have an interfaith marriage, I need to put out a declaration. I need to inform administrative authorities. Those administrative authorities have been given power to conduct inquiries. What are those inquiries about? I am an adult. When I go and marry a person of my own choice, of my own caste, of my own religion, what do I do? If I'm getting married, not a religious marriage, a civil marriage, what do? I go and give an affidavit? Is there any inquiry that is conducted? The premise here is that actually young women are not intelligent. The state is jumping in to protect. Actually, what the state is doing is that the state is paranoid. And the Indian state has always been paranoid of young women expressing their sexuality and exercising their autonomy. This is something that patriarchy and the Indian state is very, very paranoid of. What will create national integrity? What did Dr. Ambedkar say? Intercaste marriages will create national integrity. Interfaith relationships and marriages will create national integrity. And actually, these laws, they come very close to what is happening in the Uniform Civil Code in Uttarakhand, which also we have challenged. So when they say when you say that, marriage, what a conversion for marriage. I may wish to convert to the religion of my partner. And why do we assume it's always the woman who's converting? A man may
But
also convert.
that is one aspect. But in general, conversion is being regulated under these acts. Any or fraud is has to
It's
be
gone way beyond that. The problem is
Ji.
not. It is saying if somebody offers you a better way of life. You see, when you use such loose phrases, what if I marry a man of another faith and I move to Kerala? The pollution level in Kerala is way lower. The health index is much higher. Yes, my way of life will be better. So maybe I was persuaded and cajoled because of that to change my religion. This is not the space that the state can enter. And where is the evidence of this? The shoe lies on the other foot. The burden is on them to show the evidence. They cannot just, you cannot turn rhetoric into evidence. And the rhetoric may be made by the highest political executive. It makes no difference. It remains populist rhetoric and nothing more. There is zero evidence of conversions, etc. No matter how many times you say a lie, it does not become the truth. What is happening today is the people are marrying out of choice. People are gathering. Look at the way it is being used. And then where is the evidence? The evidence is in the judicial records, in the police stations. You
But ma'am,
gather
we're
for
not just talking
Christmas.
about conversion for marriage. We're talking about forced conversions, fraudulent conversions. We're
Where is
talking
that?
about
Please stop it.
allegations. No, please let me ask that question. There are what the state says is that there is evidence of money being given out. There's evidence that young children are being, uh, uh, you know, uh, uh, sort of almost groomed in a way that young children are being taught about other religions, and that is what is sort of inducing them into conversion. There is also allegations that certain religious groups have put in a lot of money. They're offering jobs, they're offering immigration to other countries. So that is where the state says is a problem with the inducement or fraud or deception. How do you
So
see that?
the state has not put any evidence. Let's not use that word. These are loose allegations the state makes. The state makes these at political platforms. Unfortunately, the state thinks the same thing is all right to be said in a courtroom also. They should distinguish between the two foras, according to me. What are they saying? They're actually spelling this out in the law, what you have asked, and that's important. That there are schools, there are hospitals. I went to a convent school for my entire schooling. I even went to a college in Delhi University, which is a Christian minority college, the St. Stephen's College. I'm an atheist. They did not convert me to Christianity. I come from a family where people practice Hinduism. You do not convert anybody because you offer them education. Why were there health facilities and education being offered in, say, Adivasi areas? Why did the state not provide? And today, when there are RSS branches and Vanvasi ashrams, what are they doing? Are they not telling people to convert to certain religions? There's a very interesting part in these laws which says if you revert to your original religion, in Rajasthan, where the governor is yet to give the assent, because there's been a change of government, there is now a Rajasthan anti-conversion law. It is awaiting assent of the governor, where they use the phrase ancestral religion. What is an ancestral religion? How many generations back will I go? And maybe my ancestral religion was animism. Hinduism, as we know it today, and as, say, my family practices, was not the original religion of this land. So if you really want to read history, you can't read it through the lens of the majoritarian state. The history will stand by itself. And therefore, to say that people will not exercise, if there is force of fraud, the state could take action prior to these, the state can still take action. These laws are not meant for that. These laws are meant to segregate, divide, and create social tensions, and they are doing it.
All right. Thank you so much for speaking to us in so much detail, Ms. Grover. The hearing, of course, now likely after about 6 weeks. We'll have to wait and see what happens there. Thank you very much, ma'am.
Thank you. Thank you.